I'm Jared Craig with the Vet Voice, and I have the pleasure of speaking with Jason Fick, who is the founder of the Social Media Freedom Foundation. And we are partnering with the Veterans for Trump group and Legacy PAC to give Jason Fick the platform to share his mission concerning the social media censorship that we have all been dealing with. During the pandemic, we've all been shut down. Many of us have been to Facebook jail. And Jason's had some headway with this. So, Jason, I'd like you to share with the audience what got you invested in this issue and what's happened since you've gotten started.
Well, thanks, Jared, for having me. I got involved in social media years ago. It was 2010, and I built a very large audience. I had about 17 million fans in early 2012. So we had built a massive audience, and during that period, and this is before most of the censorship was really the pervasive problem. It was mainly about the shift in these companies' business models. They turned their business model. It's basically a big bait and switch. They say, "Come on, use their site," and then all of a sudden they wanted to compete for content provision, right? So they were service providers who were acting to control content. What that meant was is that when they started serving up advertising, it became a direct conflict with other users in the newsfeed because they must displace us. Therefore, we became less valuable to them, and their original agreement, which was come on our site, build your reach and distribution, and you can use our services for free, all of a sudden switched to, well, no, you can't use them for free because we're going to steal it from you and sell it to somebody else. So that's essentially what happened to me. At my peak, I had almost 38 million Facebook fans. I could change national trends. Nobody knew who I was, but I started making somewhere in the neighborhood of about $300,000 a month with virtually no overhead in marketing, which was exactly what Facebook does right now. They are my straight line competitor. So fast forward a few years, and they basically destroyed all my reach and distribution and so forth. But in 2016, I caught them red-handed, absolutely dead to rights. They were committing an anti-competitive, misconduct. It was illegal, right? It violates laws, and then this is where people start to get confused because they think, well, they have terms of service; they can do whatever they want. No, terms of service do not supersede laws, and
Right.
laws don't supersede rights, right? So these
Yeah.
are these are simple principles that most people should understand. Well, here's what happened. Having caught them in 2018, we sued them for anti-competitive behavior, tortious interference, extortion, and fraud. Right? They
Right.
deliberately deceived everyone, and they are themselves not only a service provider, but they are also content providers. Well, this brings up another confusion: the whole publishing issue. Well, see,
Right.
here's the thing. Content providers are anybody that manipulate content. That includes the websites. But the publisher, specifically the publisher or speaker, as the law denotes, this is we're talking about Section 230 here, which protects these companies. The publisher or speaker is the original publisher. That's who puts it there. They push that button that says
Right.
publish. They, meaning these websites, these service providers, cannot be treated as that publisher. It's specific. But the way that courts have read it over the past 2.5 decades, they read it wrong. Plain and simple, it's the English language. They read it as they cannot be treated as a publisher or speaker in the general sense. Meaning, if they act in a secondary publishing capacity, which they're doing, they can't be treated as themselves. It became unfettered immunity. Now, what happened? We took the case all the way to the Supreme Court. We argued the merits of it, the legal argument, and the courts couldn't care less. They had the most ridiculous responses that, as I'm sure, as Jared, if you went through it as a lawyer, you'd understand that it doesn't make any sense. For example, they said that there's no duplicative protections, perhaps because they developed information in part. And you go, well, if all publication decisions are protected, that would include content development. It made no sense at all.
Right. Right.
So then we brought up another problem. So we filed what's called a motion 60B, which essentially says, hey, you got it wrong. We got new law here that says otherwise. And what we based that on was the Enigma case, right? Enigma versus Malwarebytes. And the Enigma case brought up something very interesting that no one talks about. It says in the law, right? This is 230C. This is the first part. It says that they must be a good Samaritan. Well, what is that? That's called a general provision. Now, think of it this way. This law is an affirmative defense, very much like self-defense. And the basic principle of self-defense is that you have to act in the defense of yourself or others, correct?
Right.
That's what's called an intelligible principle formally. That's its name. And there's a reason it's in quotes in the law. It's articulated by Congress, meaning the baseline representation is they have to prove that they act as a good Samaritan. And no court has ever applied that. None. And we said, wait a second. Enigma brought up Good Samaritan. We argued that their actions were not as a Good Samaritan because, of course, acting for your own financial benefit. Now, a lot of people were worried about the censorship. We'll get to that. But if you think about it in the terms of money, courts understand money.
Right.
If you're acting for your own financial benefit, you're sure as heck not a good Samaritan, are you? Because you're not acting for the good of others. You would immediately fail automatically. So we said, well, wait a second, that can't be the case, because if you just can't treat them as a publisher, they at least have the motivation that matters, right? No, the court turned around and said, no, the motivation, the intelligible principle doesn't apply. It doesn't matter how they do it. Well, now there's a confusion because you go, well, wait a second. If they can't be treated as a publisher but act as a publisher, it means they can do anything they want and the motive doesn't even matter.
Wow.
They call that unfettered immunity. They can't restrict our rights, the third party's rights, under unfettered government immunity. It's unconstitutional. And of course, there was a case, Darkesi versus the SEC, that determined, guess what? If it doesn't have an intelligible principle, it's unconstitutional. But we raised that question to the courts. And what did the Ninth Circuit Court do? Dismissed us on timeliness. And then we went back to them and said, well, wait a second, you're now willfully violating my constitutional rights here. And they said, denied. So we went to the Supreme Court a second time. We brought all this up to the Supreme Court. And believe it or not, by this point, the Fourth Circuit Court ruled a completely different decision that absolutely undermines all of the existing precedent, destroyed it, went all the way back to Zoran versus American Online, which is the first case. And they said, nope, this doesn't work. And you know what? Supreme Court denied us cert too. We could have fixed this years ago. Now, this leaves us in a position where the reality is not what is wrong. We know what's wrong. Section 230C1 is misread. It is misapplied. We know it 100%. The problem has become, how do we get the courts to do their job, right? Because that's just it. They're just avoiding it. They're not doing it. Well, recently we filed something called a procedural rule 5.1 constitutional challenge. And the reason for that is because I was concretely, particularly denied of my due process constitutional right, which is the injury in fact we are now complaining of, which gives me the standing to bring a constitutional challenge of the federal statute. Well, we filed that constitutional challenge, and we basically put the United States in a catch-22 that is unbelievable. We might actually have them now. The reason is that in that constitutional challenge, the argument is this: if the court is right that 230C1 protects all publishing, okay, and the intelligible principle doesn't apply, it's unconstitutional, meaning it needs to be struck.
Right.
But if they're wrong and that 230C1 actually doesn't protect any conduct at all because it prevents them from being treated as someone else, then it is constitutional, but the court's still wrong. Either way, we've got them. We've known the problem for years. The DOJ agrees with us. Ted Cruz and his amicus agreed with us. Attorney General Paxton and his amicus agreed with us. We're right. It's undeniable that we're right. The question is, now the court has to fix this. And the reason I say it has to is because it not only says that the court must certify to the Attorney General that a constitutional question is raised, but my right to do so is, quote, not forfeitable. They don't get away from this. So they are now jammed in a catch-22 where we may legitimately change the future of America by changing the protections of internet, of these big tech internet companies.
They're doing it to promote one political argument versus the other.
Well,
It is
let me just
exactly
inject this if
choosing
I may.
sides.
If I may, let me inject this, is that
Sure.
my argument is an antitrust argument. It's about money, it's about
Yeah.
business, it's about competition and so forth. However, if at the core of this argument, the Good Samaritan general provision applies, the motivation applies to everything and anything they do to get government protection. It's not that they can't do it under the First Amendment right. There's another argument. Well, they have a First Amendment right. Of course they do. They can take it down. That's not a problem. But if they break laws, the government's not going to protect them, right?
Right.
That's the point of an affirmative defense. It shifts that burden of proof to them to prove that they act as a good Samaritan to get the government, protection. And the government has let us down. If they're applying their rules subjective, just however they choose to block specific types of speech, that's again not acting as a good Samaritan in the interest of the
Right.
public, because only the government can protect statutes that protect the public. So as Ted Cruz and Hawley and everybody else are talking about a neutral public forum, that's just a more colloquial way of saying no. If the government's going to grant them a protection from statute, like an affirmative defense, then they have to be acting in the interest of the public, not their own interests or their own ideas or ideals, or none of that gets protected. And now, I also want to clarify one other thing, and I think you'll understand this too. Just because they restrict your materials, like restrict your content, whatever, doesn't mean they break the law. They can still do that. The question is why did they do it? If they did it because, let's say, you're black or Jewish or anything, that's discriminatory, they
Right.
broke other laws. Now you have a claim. But if they took it down because they just simply don't like it, there's no cause of action there. So again, this is just a matter of lifting these bizarre, absurd, unfettered protections so that guys like you and me and every one of your audience can at least have a fair shot that, look, if you're going to break the law and you're going to really stick it to me, I should be able to bring my grievance against Facebook, and the United States should not stand in the way unless the United States determines without a shadow of a doubt that they acted as a good Samaritan in good faith to restrict my speech.
I think this hits the kitchen table issues. Now, we believe that, freedom of speech is paramount to our country, different from every other country. But the
Mhm.
people of this nation have taken it for granted because they don't know how the rest of the world operates. And that's what sets us apart from the country that we came from, the British crown and tyrannical dictatorships there, and the dictatorships around the world. If our freedom of speech falls, there is no other country that has freedom of speech. And we need to instill that in our youth as they're standing up and screaming a bunch of nonsense from the left, that we're protecting their right to do so. We might
Everything.
disagree with it, but we're protecting.
Without free speech, we can't fix anything because
Right.
people are not paying attention to this is the most pervasive problem in the United States right now. Our free speech goes, so does everything else because you won't be able to challenge it. Foundation, we could really use some financial support because I have basically done this myself. We have not gotten, until speaking with you and the Legacy PAC and VFAF, sorry. Um, we don't get the big support because they just, a lot of people slough me off as just a sort of just a little nuisance. No, this is not nuisance. We had to break 2.5 decades of bad precedent. We
Right.
know how, and now we may have forced them to do it. So this is pretty much for all the marbles. If we get this pulled off, it's big.
Well, Jason, one thing that we pride ourselves in is creating a platform with Legacy PAC, Veterans for Trump, for what's really going on. We've been shadow banned by social media. We're partially being shadow banned or blocked by local, state level GOPs and the media circus that is focusing on things that don't matter, while stories like yours might fall into the shadows, or people might not take it as earth shattering as it actually is. So we want to provide you the platform to do so, and we push it out where other people might be scared to do so. We're happy to do it. We're trying to save this country. We're trying to save our rights, and you are on the front line of that battle. So thank you for doing what you're doing. The fight goes on and on. It's a thankless job that we all do to save America, but our children, our grandchildren, should thank us for so long
That's
as
what
we
this
don't
is for.
let them fall to the left.
Yeah.
But I'll put out all your contact information. Feel free to reach out to me. Keep up with us, and we hope that this is the avalanche flowing in the right direction.
Yeah. That's
So thank you very much. Thank you,
thank
Jason.
you. I look forward to working with you.